Okay, good morning, everyone. My name is Joanna. I'm from the Canadian Constitution Foundation, and we have a really juicy conversation ahead. I want to say that if you read the panel description about the bedrock principles of liberty in a free society, this is, pardon me, better? Okay. We're getting into something much more interesting than that sort of milquetoast, whatever bedrock principles of liberty are. We're actually going to dive into two of, I would say, the two most polarizing and consequential issues that are actually potentially going to decide whether or not Canada survives as an entity. Two of the stress points that we're currently experiencing on our federation. Of course, I'm talking about Indigenous reconciliation and the question of Alberta autonomy. So we have, thank you. I guess that's for the Alberta autonomy question. I'll start by introducing my friend and colleague to my right, John Weston, who served as MP for West Vancouver, Sunshine Coast, Sea to Sky Country from 2008 to 2015. He has brought extensive constitutional law expertise to Parliament. He was mentored by the founder of this very organization, Preston Manning. He has a constitutional background, working on patriating the Constitution for BC and Quebec, served as counsel in the landmark Chief Mountain Challenge of the Nisga'a Treaty, which we'll get into. And he was the founder of the organization, which I'm very privileged to lead, the CCF, in 2003. He served on the advisory committee to the Minister of Aboriginal Affairs, and he continues this advocacy role as a public affairs advisor, where he advises residents recently in Pender Harbour in BC on land rights issues with the provincial government. John is very committed to the health and well-being of Canadians. He's the founder of the Canadian Health and Fitness Institute with the ambitious goal of making Canada the fittest nation on earth by 2030. And hold your applause for a moment. I'm going to now introduce the gentleman to my left, my colleague Keith Wilson, King's Counsel, who is a constitutional lawyer based in Edmonton, who famously and ably represented the Freedom Convoy, and he believes that Alberta has a historic opportunity to prosper by leveraging its power and natural resources. So we're going to start with the question of Indigenous affairs and reconciliation. So just to tee this up, many of you will be aware of this, no doubt. But last month, a very consequential decision came out of the BC Supreme Court. The BC Supreme Court released a massive 800-page decision after an unusually long trial, and it recognized that the Cowichan tribes hold Aboriginal title to part of their historic village area in Richmond, BC, along the south arm of the Fraser River, and also confirmed a constitutionally protected right to fish for food there. Think of Aboriginal title as a constitution-level property right that is said to predate Canada and sits above regular fee simple ownership in the legal hierarchy. Within the title area, the court found that some fee simple interests held by the Crown and by the City of Richmond cannot stand as is because they unjustifiably infringe Cowichan title. It did not rule on private homeowners' titles because in this case private owners weren't sued here, but it certainly presaged conflict there. It emphasized that Aboriginal title is constitutionally superior, which naturally raises questions about the amount of litigation and uncertainty in reconciling these diverse interests. So, John, I'm going to kick it off to you, and I know that you've studied this decision, and I know that you've worked on surrounding issues for decades, in fact. So, given the Cowichan tribe's decision, what do you think conservative leadership would look like in creating a reconciliation framework that brings Indigenous peoples fully into Canadian society while maintaining, and this is the crucial part that I think both you and I are passionate about. I also forgot to mention that John and I are co-authoring a forthcoming book called First Nations and the Future of Canada with two Nisga'a ancestral elders, Chief Mountain and Mercy Thomas. So how do we bring Indigenous peoples into Canadian society, recognize their dignity, while recognizing and maintaining constitutional equality for all Canadians?
Well, thanks, Joanna. That was a mouthful. You mentioned being mentored by Preston Manning, and I was just thinking as we listened to Jamil about the difference between politics and leadership. And you know that Jamil Javani, after he ceases being an MP, is still going to be a leader. You know that, right? I mean, there is mentoring young people. And I can't help but think of all of us in this room being mentored today by Preston Manning. If Preston Manning was on the scene when I first entered politics, I remember Globe and Mail writer Jeffrey Simpson did a real hatchet job on me after I was first nominated, and it was really intimidating. Unlike you, Keith, who's an experienced litigator, probably intimidated by nothing, it was really something to be on the front page of the Globe and Mail. And who showed up to say, it's okay, this you'll get past? Who showed up to mentor me and has been a constant influence in my life? Preston Manning. And here we are, beneficiaries of the great institute that he created. So I just want to thank Preston Manning one more time. And this relates to where we're going with the discussion of First Nations. I have to be careful what I'm saying today because I'm under the watchful eye of my son Shane Weston, who is press secretary in the office of Pierre Poilievre. But I do believe that how we answer today's question on Indigenous affairs, how we answer the question that Jamil was asking about the role of young people in the future, these are leader questions. They're not just political questions. And it strikes me that at a time when the Liberal Prime Minister has stolen major platform items from the Conservative Party, that we Conservatives have to have real vision to offer Canadians, not oppositional politics, but real vision for the future to make people excited about being Canadian. And I was a little discouraged by some of what Derek said. I'm excited to be a Canadian, and so I'm excited to jump in to answer your question. So let's look at this case. It was over 800 pages, as you said. The longest trial in Canadian history, 514 days. If you count the lawyers at the beginning of the judgment, over 60 lawyers involved. It dealt with 780 acres on an island called Lulu Island, which is next to Sea Island. You land on Sea Island when you arrive at YVR. So most of you have probably looked at Lulu Island on the way in. And what was really consequential about this, potentially the most monumental case in Aboriginal affairs, is that the court squarely said that Aboriginal title can exist on top of fee simple. So that grants issued by the Crown, which are the basis of the private property that you own, if you own a house or something else in this country, are subject to Aboriginal rights. And you may say, well, how could that happen? How could you undermine a shibboleth of peace, order, and good government, and that is the right to own land? How could that be undermined? Was that just bad legal reasoning? In fact, it reflected bad political leadership. And so if you look at the court decision and you wade through something like paragraph 2,610 or something, Judge Young says the BC government did not argue that a Crown grant overrides Aboriginal title. The BC government chose not to raise the most potent defense of rights to property that it could have. And the federal government, which was also a party in the case, amended its pleadings to follow the lead of BC. So, within days, Attorney General Nikki Sharma, the BC Attorney General, announced there would be an appeal of this case. And you may think, the NDP BC government is hastening to the defense of property rights in the country that we all live in. No. Be careful in what you conclude about this appeal, because she cannot now raise in appeal a defense that she didn't raise in the Supreme Court. And furthermore, there is a pattern that we've seen where the BC government has consistently undermined confidence in rights to property. You look at, for instance, the Pender Harbor area, an area in the riding I used to represent of the Sunshine Coast, where landowners have been appalled that the BC government has been surreptitiously negotiating with the Seashell First Nation about foreshore rights. That's rights to land that interfaces with the ocean. Recently, the BC government entered into an agreement with the Haida First Nation that said explicitly that Aboriginal rights can coexist with fee simple, but didn't bother to explain how. And so Joanna mentioned that private landowners were not defendants in the Cowichan case, but defendants included the governments of Canada and BC and the city of Richmond, and the judgment declared that lands must be returned to the Cowichan that are currently owned by Canada and BC and by the city of Richmond. And there's a time frame within which that must occur. Now, even though the court didn't rule on third-party landowners, people like you and me who just own land as, we call it, fee simple landowners, that's a clear implication from the case. And don't think this is just another wacky British Columbia development. Remember when I spoke on the Chief Mountain case in Calgary way back in 2004, the saying was that there was a wave that started on the west side of the Rockies and became a tidal wave when it hit Alberta. And that's consistently some of the implications, and Keith, you may want to speak about this. There's reasons why Albertans have problems with Ontario and Quebec, but British Columbia is a peculiar neighbor sometimes in Confederation. But this case affects everybody in the country. So this is something we have to deal with. So Joanna, your question was, what do we do with this as conservatives? Well, there's no constitutional litigation case that happens in a vacuum. When the courts have to face these issues that are really about the framing of our country, they're very wont to take judicial notice of things that are happening outside the courtroom. And so it's important for us as conservatives to formulate a vision that talks about equality over legal separation. We'll talk a little bit about the Chief Mountain case later, but the Chief Mountain case was extremely important because for the first time, the courts had to determine whether Aboriginal law or Sharia law or any other law could prevail over Canadian law. What takes precedence in the case of conflict? And because the governments of BC and the governments of Canada were enthusiastic about saying Aboriginal law could prevail in certain cases, you have the unfolding chaos that we end up with today. So, number one, we conservatives need to decide, do we believe in equality over inequality? Should rights of Canadians be equal, regardless of race? Should we be proposing and seeking integration of First Nations people? If that's our vision, then it's time for us to stand up and say that's our vision. And by the way, it's really important what Joanna said, that we're writing this book in conjunction with First Nations elders. I don't know if there are First Nations people in the room, but we have to be having this conversation in partnership, co-creating. We can't just say what we want it to be and ignore the interests of First Nations persons. We have to create a vision, and I'm thinking 25 years ahead now. Jamil Javani, where are you? I think you'd agree with this. What kind of Canada do we want if we create a country where we're walking together in equality? I'm quoting Chief Mountain right now. We're creating a prosperous country, a country that is peaceful and free, a country in which we can really thrive and where Canadians can flourish. That's the country I want to grow up in, and I want Shane and others to grow up into.
Yeah. Thank you, John. So to put a little bit of a sharper point on this, let's jump right into the Chief Mountain case and bring some color to it, because I think it really foreshadowed the crisis that we seem to have just driven headlong into with this Cowichan tribe decision. And let's give some color. So you were deeply involved, of course, 20 years ago with Chief Mountain, who is a Nisga'a hereditary chief who challenged his own nation's treaty with the BC government because he believed that it created unequal citizenship, undermined his constitutional principles, his ability to avail himself of the guarantees of the Constitution just because of the specifics of this treaty with BC. We're writing a book about this, and also I know that you had a very interesting, intimate conversation with the two Indigenous elders who are co-authors, Chief Mountain and Mercy Thomas, about the Cowichan tribe's decision and heard their perspective on it. So why is this case relevant today? What could have been averted 20 years ago? What happened with the case? Tell us about it, because this is a really interesting and I would say like buried Canadian story that actually explains a lot about why we are where we are in 2025.
So imagine 90-year-old matriarch Nisbalata Mercy Thomas, 73-year-old Chief Mountain, chiseled face, charismatic character, has a hereditary title that goes way back. They are completely committed to the preciousness of their land and the spiritual relationship that they hold vis-a-vis their land. We've known each other for 25 years. You pointed out, Joanna, I represented them in the courts, and we've become friends. So it's a very lovely relationship that we can talk about any of these issues which may divide us, but we can do it in a way that we somehow find a path forward. So 2 Sunday nights ago, I get this urgent text from Chief Mountain. For the first time in 25 years, Chief Mountain and Mercy are summoning me to a meeting. It's a telephone meeting, but it had always gone the other way. So on this occasion, they were very upset because they'd seen something I'd written from my perspective about the Cowichan case. And my perspective was it unhinges confidence in our economy, it undermines peace, order, and good government. Canada lost over $80 billion in direct investment in the first half of this year, partly because of uncertainty relating to these types of issues. So you know where I'm coming from. And I suspect many people in the room would share my concerns. Their concern was, wait a second, this is an acknowledgement of Aboriginal title. For First Nations persons who believe that the law relating to land and land ownership predates Confederation, predates the BNA Act, where does the authority for the Crown come from to issue those titles that end up being what we call fee simple? So they had a different perspective. So, you know, and Jamil confessed his faith. I'm also a Christian. Leading to that phone call, I really had to pray hard because I thought that our book project, the relationship was going to go off the rails. An hour and a half of very tense conversation. We understood we have to respect one another's views on these things. For First Nations persons, it's not good for the country to be unhinged. It's not good for investors to flee. It's not good for there to be no jobs for First Nations persons. It's not good for young First Nations people to have no hope. So they listened. They understood that we have a problem if as political leaders and governmental leaders, we don't sort out the consequences of the Cowichan case. But I also understood, and I hope everyone in the room understands, that we have to listen hard. There's some sacred relationships here between land and First Nations people that have to be respected. So Joanna and I and the other two, we're going to work through this in the book. This is not an unabashed book promotion moment, but I do hope you get the book.
Okay, so last question to you, John, to sort of leave us with a note of hope. You've argued that the courts were responding to essentially a void of leadership left by politicians. So what should informed, compassionate, long-term strategically thinking conservative leaders be doing right now to provide the constitutional clarity that our politicians have obviously failed to deliver for the last 25 years at least?
This is not an easy ask, and I'm going to ask it anyway. I'm not going to ask it expecting Pierre and the Conservative shadow cabinet to take this on, because I've been in the caucus room before. I've sat on the caucus advisory committee to the Aboriginal Affairs Minister. I've seen how decisions were made on an ad hoc basis. Let's kick it down the road. We'll make one land claim decision here. We'll award $1 million or $2 million there. We'll give a golf course here. And when I would ask, what's our vision? What are our overarching principles? Where are we going 25 years hence? You can almost hear the eyes rolling in the room. That's not a good politically expedient thing to deal with, John Weston. So I'm going to ask it anyway. I'm going to say that if we don't resolve the issues that we're talking about in the room today, the future for young men, if we don't resolve issues about how we integrate 638 First Nations, can you imagine, each with sovereign authority, each with their own laws? How do we actually take ourselves seriously, let alone have other people around the world take us seriously, if we don't create a future, a vision for Canada where equality of opportunity is truly the goal, the horizon, that arc to pursue? If we don't pursue integration, if we don't seek ways we can bring ourselves together for the benefit of First Nations people and the benefit of other Canadians. That's what I'm asking Pierre and the Conservative Shadow Cabinet to do today, not only to get elected next time, but to make sure that we have something to hope for in the future. Do you all agree? Yeah.
Okay, great. Before we turn to you and to the question of Alberta autonomy, Keith, I wanted to give you an opportunity to weigh in. We have a framework emerging, respect for Aboriginal title, respect for Section 35 of the Constitution, but within a baseline constitutional guardrail of the requirements, basic requirements of a sovereign country. So Keith, there is this obvious conflict that comes up when you talk about Alberta secession, which you believe is necessary. Treaty rights, which of course are older than the BNA Act. So how do you see treaty rights and Indigenous sovereignty as coexisting with the path that you foresee for Albertan autonomy?
Sure. Two things. First of all, with respect to the Cowichan decision, one of the things that's unique about Alberta is that the entirety of our landmass is covered by three treaties, Treaties 6, 7, and 8. And you just need to glance at the first page of those treaties, and they contain every legal and English word possible to denote the surrendering, the ceding, the giving up, the releasing of Aboriginal title to the lands. So we're fortunate in that we have these treaties. So I don't think we're going to struggle with the very profoundly serious problem that this Cowichan decision creates for so many other places in our country. And each time so far in our case law, when First Nation has tried to challenge one of the treaties in Alberta to claim that they didn't actually lose their title, that notion's been rejected by the courts. There's still two cases, I believe, Saskatchewan before the courts. They're sort of slow on. So that would be just an observation about the unique situation Alberta is in, that every acre of our land is already been ceded through treaty. With respect to the succession issue, the Supreme Court Canada 1998 reference case, as well as the Clarity Act, is clear that Aboriginal groups or stations have a seat at the table should a province vote in
Okay, great. Well, let's get into the meat of it. So, as CEO of the Canadian Constitution Foundation, one of our pillars of strategic litigation is freedom through federalism, and we're very proud to have contributed to important legal precedents at the Supreme Court of Canada and other levels that have carved out constitutionally protected spheres of provincial autonomy. For example, in the Impact Assessment Act reference, there's a new challenge, which I'm sure you're aware of, brought by Alberta to the revised Impact Assessment Act because the federal government didn't really do a good job. Also, we had a case last year from the Supreme Court called AG Canada versus AG Quebec that made it clear that the federal government cannot direct provincial agencies on how to implement policy. But there are people like my friend Keith that have given up on the prospect of pursuing Alberta's interests and provincial interests under the framework of confederation completely. And I think it's important that we, whether we agree or not, I don't agree, but that we hear the full case for it and that we engage for it. So Keith, make the best conservative case for Alberta autonomy, where you see the independence movement as being at currently, and how you see the mechanics of independence playing out with regards to legal certainty, property rights, the rule of law, all of these things that as conservatives we really cherish.
In 3 minutes, right?
7 minutes.
Oh, I can do it 4. So, firstly, Canada's unique among democracies in the world in that in most countries, for me talking about Alberta seceding and becoming an independent country, I would be talking to you from jail. And I'm not, thank goodness, because the Supreme Court of Canada in the 1998 reference case interpreted our Constitution and constitutional doctrines as laying out a legal process through which any province can go to become independent, to leave the Confederation, okay? And then the federal government supplemented that with the Federal Clarity Act. And it basically says, as I said earlier, that if a province votes on a clear question and a clear majority to leave, then the federal government, the other provinces, and First Nations are then under a positive legal duty to enter into good faith negotiations as to the terms of the province leaving. So this is very unusual. I've tried to find, I think I found some African nation that had something, in maybe Barbados or something, but you get the idea. So what's first to me makes the prospect of Alberta independence viable is there's a legal pathway. And within that, to jump to the last part of the question, there's paragraph 155 of the Supreme Court of Canada decision. It's a little cryptic, but it talks about, it's like the Supreme Court anticipated the scenario whereby good faith negotiations either don't occur or don't result in a successful deal for the terms of secession. And the Supreme Court of Canada noted that this does not preclude unilateral international recognition. Our new Prime Minister, Carney, a few weeks ago, demonstrated how countries around the world can unilaterally recognize other countries. He announced that with no precondition, worst negotiator in the world, that the government of Canada in September, the United Nations General Assembly is going to recognize Palestine. So I take it, and I'm a little sarcastic here, I take it he would then have no concern whatsoever if President Trump were to decide after the referendum to have the United States unilaterally recognize Alberta as an independent nation. So where I see we're at is the Alberta government for many, many years has had referendum legislation on the books. It provides for the cabinet through an order in council, so cabinet order can call for a province-wide referendum on any question that it wants, including independence. But we also have the Citizen Initiative Act. And the Citizen Initiative Act allows for a group like the Alberta Prosperity Project to petition the province to hold a referendum, and that petition process is underway. We need 177,000 signatures collected over 120 days. And so far, there's over 250,000 Albertans who have signed pledging to sign the petition, and over 35,000 people have signed up and volunteered to be canvassers. There is a competing, a nothing burger, as Justice of our Court of King's Bench referred to it, as a former politician, Thomas Lukasik, has developed a petition called Forever Canada. That's currently circulating. It's only a policy question, so it has zero impact on the independence constitutional petition. The judge himself called it a nothing burger. Wow, what a blow to Mr. Lukasik. And he has to get 395,000 signatures in 90 days. Good luck. Even if he gets them, there's no scenario under which this other petition could impact the independence movement and the viability of what Alberta Prosperity Project's doing, even considering it's currently in court being validated. So, my view is Albertans know their value, and Albertans are tired. We're tired of all the money that we send to Ottawa. We're sick and tired of what they spend it on. And we're most frustrated about, we're ready to get to work. We're ready to get our resources out of the ground. We're ready to get them to markets. We're ready to become the most prosperous country in the world. And the only reason we're not is because the federal government has these extremist policies that we all know about, C69, greenwashing, EV mandates, net zero, et cetera, et cetera. And as we've seen in the last election, the majority of Canadians seem to think that those are good policies. And, we've got a third of people who will vote for independence in Alberta no matter what you do. We've got a third of the people who will never vote. You could give them a suitcase full of cash and 3 new Teslas and they still wouldn't vote for it. And then we got the 1/3 in the middle. That 1/3 is growing. I think there'll be a referendum in 2026, and I have some optimism that, I'm sorry to say it, that Canada is structurally such that Alberta can't have a fair deal within Canada. How do you convince the following provinces, and I'll close with this because I'm probably at my time. Manitoba currently gets 19% of its budget, of its revenue from equalization payments. Quebec gets 9%, but New Brunswick gets 21%, Nova Scotia 20%, and PEI 19%. So you've got 3 provinces in Eastern Canada that get 20% of their budget from hardworking Albertans. How are you going to convince them, regardless of political ideology, to say, no, it's okay, let's change equalization so you're going to lose 20% of your revenue? So I'm optimistic that the challenges are enormous, but the pathway is there. And I think, I've said this many times, I think actually Carney's going to determine whether or not Alberta becomes independent.
I have an answer.
Thank you.
Can I?
Sure.
At the danger of actually having a brisk discussion? Well, there's almost a mirror image between the last panel and this, where Derek was kind of pessimistic about the future, and Jamil was saying, well, wait a second, don't give up. And I would say, in answer to your question, Keith, how do you persuade those provinces? How do you persuade Canadians that there needs to be a change? You have people like Keith Wilson and 250,000 Albertans say enough's enough. I wrote a column in the Vancouver Sun saying, is it time to be embarrassed as a British Columbian when the Kinder Morgan protests were happening? And Albertans, we're trying to get your resources to Tidewater because you've been shouldering the burden of Confederation's costs for 40 years. And isn't it time British Columbia and Quebec came right alongside you and supported you? Maybe the sound was on deaf ears, but the sound is becoming more furious. And I think it's time Alberta got recognized the way it should be. There is an incredible value to the country that we cherish as Canada. It is exemplary in the world, not just due to its geography, but also its history. We live in amazing peace. We have some order and we have bad government. So 3 out of 4 of the BNA Act's goals, we have a ways to go. But it's going to be visionaries like you, Keith, and other people in the room who care enough to do all this hard work that change it. I'm suggesting we've got way more to lose than to gain by breaking up. And I'm speaking from the perspective of Albertans, not just British Columbians and Quebecers. So stick with us.
We're done asking.
All right, thanks. So, Keith, you were very sanguine about the viability, the electoral viability of independence. But we know that the leader of the Conservative Party, Pierre Poilievre, recently went door-to-door campaigning against it in Battle River, Crowfoot, heartland of the separatist movement, and he won 80% of the vote. The separatist candidate got less than 2% of the vote, and there was certainly ample opportunity to send a protest vote message to Ottawa. So do you think that this movement is really viable when it really comes down to it?
Well, that's a complete misread, with all due respect, of what happened. Interestingly, as some of the people in this room know, I cut my teeth representing rural Albertans, farmers and ranchers. And I would probably estimate, seriously, 70% of my clients over the last 30 years have come from that riding. And one of them phoned me right after the election. I'm working on a litigation file for him. Very prominent family, guy in his late 60s. And he voted for Poilievre. And he said, why are these people saying that my vote for Poilievre was a vote against separatism? You know I'm a separatist. He said, but I'm a pragmatist. I wanted a conservative, if I'm going to have somebody in Ottawa, I want it to be a conservative voice. So it's respectfully, it's a complete misread to believe that the people in that riding from Stettler and Clive and Lacombe County all the way out to Hanna and the special areas and down to Drumheller and through Acme and all Torrington and all those places, man, those are the 1/3. You could literally kidnap their dog and they're still voting for independence.
Okay, so as I mentioned in my introduction, Alberta wins and loses cases within federalism. So obviously the greenhouse gas emissions case was lost under POG, which was an atrocious decision. But huge chunks of the Impact Assessment Act were struck down as unlawful overreach, and Ottawa amended the statute, and Alberta's challenging it again. But doesn't that show that constitutional contestation can work without blowing up the Federation?
No.
Say more.
I know. So, why is it that we had to litigate anything? Why is it that a federal government would place its knee on the economic engine of the country when we have such massive debt and deficit, when we have such limited GDP growth, we have such influx of need through immigration and strained infrastructure and social services? I mean, that's the first question. Why would they do this to begin with? And yeah, I'm annoyed by it, as you can tell by my face. So, it's like, well, some guy comes up and punches me in the head, and then someone says, yeah, well, the court said it was a bad thing. I'm like, well, why did he punch me in the head in the first place? So that's my first grievance. But it just goes to show, the Impact Assessment Act is absurd. One of the things it says is that, and this was the amendment that Trudeau brought in that created a huge problem, is that it says a proponent must assess the impact of the project, on the intersection of sex, gender, and other oppressive or identity factors. And no one, no lawyer, no expert, no one can agree on even what the word intersection means, other than it does not involve a red, yellow, and green light, okay? So that didn't get struck down. We have these incredible barriers that are put into our growth and our prosperity. I think any objective person to come to another country and know nothing about Canada and have all this explained to them would go, there's two groups of people who are crazy. The guys in Ottawa doing this, and the people in Alberta who are prepared to continue to put up with it.
Okay, so
I
Keith,
think-
you mentioned, did you
But
want
before you go, Joanna, I think you just made the most powerful argument that Canadians need to think twice before electing another Liberal government. I mean, there's no question. This is a government that has consistently ignored GDP and promoted, well, until very recently, relationships with the Communist Party of China. I mean, it's got so many things upside down. I mean, I was a member in the same house with the guy who was being paid to give speeches when he was a federally elected MP. His name was Justin Trudeau. He had no sense of judgment. I'm not speaking as a partisan right now. I was aghast. Who would take a helicopter flight to the Aga Khan's island when he knew that the Aga Khan Foundation was getting funding from the government of Canada? Again and again, we can fault the judgment. And certainly, we had this aberrational situation that led Canadians to suddenly go from a 22% deficit to electing the Liberals again. I'm not here to promote the Conservative Party of Canada, but it's obviously time for a change. And I think you just gave two great arguments why.
But the challenge I see, and I've tried hard. Like I didn't start at this proposition. You know, I'm a student of political history. A number of people in this room know my various pasts and the various roles or things I've done. But one of the conclusions I've come to, and with great regret and sadness, is that so many people in the other parts of Canada see the world through a fundamentally different lens than so many Albertans. We're culturally different. We really are. That's part of the hallmarks of a new nation, is to have a culture, and I think we got one. But they you know, I remember I'd be on Twitter Spaces or something, people like, oh, Poilievre's just, you know, got this much of a lead on, you know, this would be a year ago and 2 years ago and 3 years ago. And then I'd say, yeah, but it'd be the blue bar on the graph, and then there'd be the red and then the yellow, and I'd say, or the orange, I'd say, yeah, could someone add the red and the orange together, please? And they go, oh my God. So even though he's blowing away the Liberals, it didn't matter. It seems we have a situation in Canada where people in central Canada, Ontario, Quebec, and the eastern provinces, they want government to have a large role in their lives. They want government to spend a lot of money. They want government to tell them what to do. Whereas Albertans say, get out of my way, I'll look after myself, I'll get it done.
Okay, I think this is going to be the last question. So presumably as conservatives, we share values of the rule of law, legal certainty, stability. If Alberta were to move to independence, and I very hope it doesn't, how do you prevent years of legal uncertainty around title, contracts, pensions, borders, currency, debt allocation, the very uncertainty that chills investments and undermines property rights that you say you want to protect?
Well, the federal government's doing a pretty damn good job at that right now. So.
Okay, but these are just slogans.
No, I know. Yeah. No, that's fair enough. Fair enough. The level of lack of understanding about things like who owns the land in Alberta. People go, oh, it's Crown land. Yes, there's a federal crown and a provincial crown. It's owned by Alberta. Well, it's Crown land, so there's that. But I did a chart once to look at the functions and the responsibilities that the federal government actually has in our lives. How many hospitals and hospital beds does the federal government have? 0. And I could start going through the list. They have a very limited role. Military, we would definitely not have tampons in the men's bathroom. We'd save money there. But these are serious questions about banking, you know, and I've said to get that middle third, you have to answer very practical questions. The day after independence, what happens to my mortgage? What happens to my bank account? What happens, you know, well, I was just going to say car insurance. Well, that's provincial. And I could keep going down the list. But the list of things that the federal government's actually constitutionally responsible for is very small. But these are serious questions. The work needs to be done before the vote so that every reasonable uncertainty that a voter has in their mind they know the answer to, and they can decide whether they like the answer.
Okay, Keith, one more quick question. What's your red line? What's one autonomy move Alberta should not contemplate pursuing, should not pursue, because it would erode the fabric of our country and cross a line?
Violence. No violence. This needs to be done legally and peacefully.
Okay, I know it says I have 13 minutes there, but I see we have 5 minutes here, and I want to leave room for the Premier. So I have a final question to both of you. In one sentence each, or thereabouts, name one constitutional guardrail we have to protect over the next year and one specific reform that we should enact. And you can interpret that as Alberta or as Canada as you wish.
Well, we have to continue to rely on the courts, but in a sense stress test them. Hopefully they'll come around. I fear that our courts have become politicized and afraid to deal with controversial topics, and hopefully with the passage of time the courts will regain their confidence and provide a peaceful, lawful means to adjudicate disputes.
John?
Well, you asked that question, and I'm looking at my son sitting right in front of me, and I'm thinking, what do I want for my country, for my children, for our grandchildren? And I guess it would be, if I have to say one, it's freedom of expression. I want to be able to sit here and disagree with Keith, disagree with my government. I want to be able to encourage my children to disagree with me as long as they're thinking independently and they've got good values. So let's just keep expressing ourselves.
Okay, well, thank you to both of you. That was an enlightening discussion, and we're still all friends. And both Keith and John are well experienced with scrums, so if you have more questions from them, have at it. Thanks so much, and we'll see you later today.